wearing the hat of approving it. You're recommending approval to the City Council. The City Council carries the final decision authority for final subdivision. So you're looking at it for compliance with your conceptual and preliminary reviews, and then making a recommendation based on that. Then it'll go up to the City Council. The City Council will also hold a public hearing. So we have not concluded the public participation process. There'll be one more time available for the public to participate at the City Council level. So anybody interested in that, keep apprised of the agendas with the City Council, because it would likely show up whenever the Commission reaches a decision on how to recommend. So that's where we're at. If you recall, the preliminary plan and the final plan has to match, substantially comply with what your preliminary plan approval was, as well as what the PDO rezone approval entailed. And so we've discussed the PDO approval during your preliminary. It's a customized subdivision, 63 lots, a little over 17 acres. There was lots of discussion about road connections. So some of the advantages that were gained out of the PDO was a connection to the frontage road, which isn't a master planned connection, but part of that rezone process negotiated a connection to the frontage road. The other negotiation was the idea of not phasing the development, that it would be an entire property development at once in a singular piece for the purpose, particularly focusing on stormwater management. There was concern about appropriately handling that for the entire piece of property and putting that infrastructure in place. The road layouts were set during that PDO approval, so that's your customized decisions. There are 63 lots, if I remember the numbers correctly, that were approved. There's a variety of sizes approved and a variety of setbacks. So this subdivision plat's a little bit more complex because it's calling out those specific itemized expectations for this development. And so we had to set the setbacks. There are some snow storage areas on some knuckles set to make sure we had sufficient in some of the smaller frontage lots, customized setbacks, standard easements for a good portion of the property for utility services, but amended easements for the smaller lots. And so the subdivision plat in that case contains a lot more information because it's its own customized development. You looked at the preliminary approval, and I've outlined in the staff report, so this is that next step. You're to look at what was approved during the preliminary and determine if it complies with your preliminary approval. And I've also included in all the findings and actions that staff believes are appropriate. The purpose of this review at this point for recommendation is if it meets the approval standards, then the Commission is basically obligated to render the decision in favor of the development. And so that's what's important tonight, is look at the standards and find compliance for them. The applicant spent a little extra time in the submittal to make sure they covered all of the elements of your approval. You should see a response letter. Staff will always send out a letter required by ordinance to the applicant of what the conditions are of the approval, and you'll see that the applicant provided a copy response to the submittal of the plat. Just by way of clarification, staff is a recommending or advisory body. We don't approve everything, although the zoning administrator is the position I do function in, and I process the applications, but I remain not a final decision maker, only advisory. Make that clarity to it. I did find that the submittal met the requirements for final plat, and there was a couple of reviews done with the applicant, so I've determined that they submitted the plat accordingly, as indicated by ordinance. They submitted their construction plans as expected. That's attached in your full set documents. You see the response to the city engineer's review for the engineering portion of that project, and you see the applicant also providing a response to the city engineer's comments and correcting construction plans for that. They provided the utility sheets that was part of your preliminary approval. They also put in the easements, and again, you have the standard easements, 7 feet on the side and rear, 10 foot in the front, but where the smaller lots were approved, they were approved at 6 foot on the side, 10 feet in the front. And you'll see that on the plats, those are depicted out. Just try to hit the highlights for you, because one issue that was come into play was making sure that each lot had the 2,000 square foot pad. They provided an exhibit sheet directly for each lot showing the square footage of the lot, and it complies. So the buildable area of the RL zone has been satisfied. Again, I covered the utility provider sheets. The notes from Weber Basin has been included on the plat as required in their sheets. We also make sure the notes on the plat cover that this subdivision was subject to that original PDO so that everybody understands it's a unique development. It also lists all the setbacks for all the lots in notation, as well as some examples of typical. Again, the driveway location limitation on the street knuckles for the snow storage was put in place. Roadway names and addressings are complete. Secondary water notes are also in there. That leads last, in summary for me, you had items 9 and 10. This was a place of discussion with the Planning Commission, concerns about easements, depiction of easements. And so I addressed 9 and 10 separately in your report to brief you on the history of that. I briefed you on the history of the appeal to the Board of Adjustment, the settlement that was made as part of that. In that settlement, they listed the disputed easements on the preliminary plat according to Condition 9. I've attached that preliminary plat to your report so you can see what that settlement entailed. And then you have the issue of exception 17 that showed up as part of the appeal. This is the notice of, this is the claim of easement and the notices. And I'm not an expert on the title report, but there are 2 elements that you wanted to address. Also, just by way for your familiarity, some of you may be, some of you may not be, the person filing the appeal also applied to the Office of Ombudsman, the State Office of Ombudsman Office, I get that right. There was some back and forth communications with the Ombudsman Office. That, to some extent, is still not completely resolved. It doesn't have any burden from my perspective under state law. It doesn't, the Ombudsman Office can't stay an approval. It's not like a filing an appeal to the Board of Adjustment where you halt action until the appeal's done. The Ombudsman Office doesn't have that same authority. You can continue on in the process. It's just a matter of the parties requesting an interpretive value from the Ombudsman. The Ombudsman did attach the letter of the final decision to date, so I don't think it's the final decision, but in response to the multiple communications, they agreed that the preliminary plat was in place and couldn't contest that. However, they believed in their office ability to render opinion on a final application is eligible for final. There's been some discussion further with the office. As today, we received some information from the Ombudsman Office, and they're just requesting if any of the parties have further responses before they make a final decision on the matter. From our perspective, so looking at it from the code perspective, outside of somebody interpreting other provisions and laws, there's a very distinct, from our perspective, between preliminary, which is really a discovery process, and a final, which is what's expected to be on the plat once you've decided this discovery process. And that discovery process is really the baseline of that dispute that was going on. So in the preliminary, you do have the idea of the existing easements and the claimed, and staff did take a position at that time that there was a dispute, and staff was uncomfortable trying to adjudicate that for and behalf of the disputing parties. And I still maintain that as the planner. That's my advice. We are not here to adjudicate a disputed place. Now, what that means and how far it goes, there's a lot of variety of opinions. But that's a discovery process where you can include recorded and existing and claimed type easements to know what you're dealing with. The final subdivision narrows that, from our opinion. And my opinion is it narrows it now to existing easements. It's no longer what's claimed, but what's existing. And when you look at the submittal requirements of how it's defined in the subdivision ordinance, I tried to provide that to you, a reference to you, that it's according to what you have in the title report. During the subdivision final process, you have to update your title report. And that title report is the place that we're looking for all recordings against the piece of property. And the applicant has submitted an updated title report, and the notations about exception 17 and so forth, those have been changed, and now it's looking at exception 20 under the new title report. And exception 20 does list your condition 10, in my opinion, was you wanted a plat note showing the book and page number of that notice of claim. And so a notice of claim is not something that I can be technical. What does that mean? What does it entail legally? It's just a notice of claim. And so that notice of claim, book and page, has been listed in note 2, I believe, of the subdivision plat. And so handling that difficult matter of condition 9 and 10 and the distinguishment between preliminary as a discovery and the final being what's recorded, what's the existing recorded documents against the property, I believe advisory that they've met your condition 9 and 10 of your preliminary approval. But also, ultimately, you're the decision maker. So with that, I summarize your final subdivision review process. I state that this is a plan development overlay conceptual approval as part of a past legislative decision which finalized that conceptual layout. The preliminary subdivision is required to meet that conceptual layout, substantially meet that conceptual layout, and anything that was approved on that layout, as well as any variations that were allowed by that layout. And believe that the final plat meets that PDO. I summarized, again, the preliminary. I believe that it meets your preliminary approval. And again, I just reiterate that I'm advisory to you. So the recommendation from staff is at this point is it meets that final review, compliance with the conceptual, so you'll want to debate that. And I believe you should forward a positive recommendation for approval to the City Council, and I give you findings A through D justifying that. So with that, open to questions or
Okay,
let me do.
thank you, Corey. So I guess part of my struggle with this one is I've thought about this, well, really since the last time we saw this back in March. Was that last time? April? Whenever it was, last spring. So the requirement, of course, is, let's see, that's the one in 15030L, right? That's the
Right.
big one that we're talking about. Which says existing, that's not it.
The one that's existing or claims.
Well, this one talks about sewers, that's not it. Which is the one that we're talking about here? It's not L.
I?
Oh, it is L. I can't tell the difference between a J and an L.
Okay.
Okay,
The claim should be nearly the end sentence.
so the location, principal dimension, and names of all existing or recorded streets, alleys, and easements, both within the proposed subdivision and within 100 feet of the boundary thereof, showing whether recorded or claimed by usage. So the The requirement is just that the plat show them,
Preliminary plat show that,
that the preliminary plat show them.
yeah.
But there's no requirement in the code that we do anything about that.
That's my opinion, is you're on a discovery mode, and you can make some decisions based on what you understand, but, you know, we have canals within a certain distance. Is the canal there or not? Part of it's just helping you to discover what the contextual relationship was with the plat. If you discover a canal within 100 feet, it needs to go on to the Davis County Commission for review under their, if it's the stormwater management canal. And so you are on a discovery, but I still take the position that if there is a dispute that involves a claim of usage and it's not recorded against the property, what venue expertise, engineering, qualifications do I as a staff member have to either validate or disvalidate that claim? And I look at the same role as the Planning Commission. You know, where is the authority of the Planning Commission? And it just sits right within the code. You know, codes can be broad for discovery, but we don't use a lot of the information that comes in. Sometimes we use the information that comes in, but it's really just trying to get a big picture of the property at preliminary. And obviously, if a claim is perfected, it could affect something if it's perfected. But I don't think our ordinances are trying to allow us to perfect it. And I think the two parties in the dispute need to resolve the matter between themselves at some certain point. The subdivision process is really, what does the code require for preliminary? It's complete. What does it require for final? If that's complete, the claim just continues to be noticed as a claim as it is on the plat.
So in this particular case, the note in the, the note in the staff report about the settlement prior to the Board of Adjustment meeting is that Symphony would revise the preliminary plat to include said prescriptive easement, but that both sides would reserve their rights, claims, defenses, et cetera, for litigation. So, and Symphony did that, they went back and they added on the disputed claim, right? Is I think the
Right,
way
they
it was
did add it onto the
described.
plat for, as they said, I think in their notation, is overabundance of caution.
Yeah, I mean, I think on this updated preliminary plat, it's listed right there, it's disputed easement area 1, C note 4, and there's a whole note about it. So they did it, they listed it. But then, I guess kind of like you're saying, if it were to be perfected later, that's a different thing, and I guess part of the problem that I'm having with this, maybe Corey or Lisa, is I know that we are not the adjudicators of the perfectness, I'm not an attorney, of the claim, but, you know, how much weight do we give something like that? Because if you were to perfect that claim, it could definitely affect all those lots along that
Right.
one side.
And I think Commissioner Kara brought that up during the preliminary process. I think that was exactly the point Commissioner Kara was bringing up. You know, what is the purpose of LUBMA? What are the purpose of these rules? And we obviously in the discussion didn't see in the same viewpoint, whether we were off 180 or 70 degrees, I don't know, but we did see it differently. And here's why, you know, it's my advice to it, and that's what it is, the professional planner's advice. I'm not an attorney either, and none of my decisions are binding. But I look at the land uses, yes, we're trying to create a fair process for everybody to be engaged in a transparent realm. Don't disagree with that. But we also hit a point where I see more and more under the Land Use Management Act where they continue to narrow the cities and counties as they decide. And they do that because there's a lot of disputes that happen, and what the state legislature is sending the message, and the continued training that I get at our conferences and legislative updates, is cities. There are things out there that you just shouldn't be involved in. They're private land use matters. Stick to your rules, stick to your codes, and approve accordingly. So every time I go to the land use law training twice a year, they bring up case laws and cases from the ombudsman office. And the clear message every time is stick to what your ordinance says. Do what your ordinance says. Don't operate outside of that. And so I look at this issue of claim. There might be a legitimate claim. I'm not trying to take the position whether the claim is correct and would be perfected or wouldn't be. I don't think that's my advisory role. I don't think it's also of the city per se in its whole. That's a risk on the person making the application. If they make the application and they don't prevail, that's going to be an impact of what hits them in the marketability. Now, what could be said is, well, aren't you planners planning for the future in the best interests of the future? Yes, we are, but within a framework. And that's where I don't think LUDMA gets us to go in and say, let's step outside of the framework of the ordinances and let's start taking in testimony and witness and legal arguments. I think both parties are at risk in this dispute. One, if we took a position on one party, it would upset them. If we took a full position on another party, we would upset them. We can't take that position unless it's in our ordinances to take that position, from my standpoint. And both are at risk. But if we went in and said, we've decided to put on our hat and determine the final outcome, that's going to disappoint another party. Another party is saying, hey, I want you to put on the hat to define that outcome. And we say, well, that could disappoint that other party. This is a dispute between you two parties. And although it would be sad to see a certain outcome, that's the risk of the landowner. They need to decide that risk. We're just going to stay in the framework. And that's why I don't think LUDMA extends out further, even though it seems passionately in a future planning that we should. I see the Ombudsman Office was invented to prohibit that.
So, and then in this case, carrying it forward, just like you said, the final subdivision, this final plat narrows it down. So we're not going to talk about whether recorded or claimed by usage. We're just going to say existing and proposed easements just have to be labeled.
A little bit, that's true, but that's not 100% accurate to represent, because your condition number 10 said you wanted that claim to be shown as book and page on the plat. But that's where you ended interfering. So the claim has now been listed on that plat. Whether the claim perfects itself or goes away, between the disputing parties.
So then when, you know, a potential home buyer comes along and wants to buy one of those properties on the north side, when they get their title report, in theory, that's where it would show up as one of the exceptions of their.
Right. Well, it won't show up on their exception, per se, because it's going to be whatever is recorded on that lot
Right,
associated
so,
with that.
If you're lot 123 is what you're saying.
yeah, that's what I'm
It's going
saying.
to show up on your title report.
No, Mason?
I'm not
I don't know, but
I'm not a title report expert. But here's the risk, is if the lot is sold and the claims prospected wasn't disclosed, that's a risk. If the lot is sold and it is a note on the plat, then you bought it as is.
Yeah. So that's where I'm going. You can see that's where I'm going, is that let's consider our future neighbors who potentially buy these properties, what kind of notice do they get that this is hanging out there?
Well, they'll have what's recorded on the plat.
Yeah.
That shows up in their title work, what's recorded on the plat. And then if there's a future dispute, then that's really the person selling the property.
So they'd see the notice of claim.
They would see the notice of claim.
Notice of interest.
Notice of interest?
Yeah, excuse me, I keep saying claim.
Yeah.
Notice of interest.
And then underneath it says
Claimant.
claiming. And that shows up in whatever that results out. I mean, again, I think that's where I'm trying to stay, as much as seemingly it doesn't seem like it, neutral. This is where I don't think LUDMA extends into. These are just risks inherent with the pieces of property. And if it's not perfected, it's not perfected. And if it gets perfected later, then the person who failed to recognize that suffers those consequences with whatever they've done with their property later.
Right. So, you know, in this case, especially where it's an administrative recommendation, as it says, our duty here is to determine its compliance with the existing code, which in this case, the code for a final plat just talks about all existing and proposed easements shall be clearly labeled and identified, which they're gonna do. They'll identify it, or the notice of interest will be identified on there, right? But then it's not up to us to finalize any of that stuff. It is, I guess you could say, in the best interest of the developer applicant to,
Yeah, because as much as this has been frustrating to all parties, the reality of it is that we're not trying to take either side to it. You know, it may, in emotions, it may be misinterpreted that we're favoring what the code language says of the individuals, and that's been disputed during the preliminary, very clearly, the appeal being filed. But the settlement also agreed to certain terms with the preliminary that it was still just in that claim category without perfection. And I just feel like this is really for the two parties to either come to an agreement about, because I don't want to say either party prevails in a court. I don't know who would prevail in court. Frankly, just to probably be, Lisa kicked me, I would find it interesting to be sitting in court after going through all of this in this subdivision. But that's it. That's as far as my role goes, is I would be interested. But I'm looking at our code in the box it's in.
okay. All right, thank you, Corey. I've dominated the question asking long enough. Spencer?
Got two questions, at least to start, and I'd love to hear our fellow commission members' input. My first question is related, not taking sides, but if one side prevails and an easement or a claim against the property is substantiated, what mechanism is in place to amend the plat either way, whether it's in the interest of the applicant or in the interest of the claimant on the easement?
It's a great question. The first
Because
one,
at some point, they would want to,
Yeah.
or the other party would want to require
exactly.
the owner to update.
Yeah, whatever the final
plat.
decision is. So let's just take the notes. The notes could go on and continue, and then there's just a record of eventually over time that claim wasn't perfected. But likely what I would see is a plat amendment changing the notes. And you could do
And is
that.
there a mechanism that forces that?
No, not from my knowledge. It would force it. It'd be up to the owners of the subdivision to decide if they want to amend the notes, because they don't want that to be on a future
For the
future
applicant-
sales of a lot.
For the applicant's side, but what about the claimant's side?
The claimant side, if it's, let's go to that they perfect now the easement and it goes into play. The property owner then decides to live with that easement. It's no different in some sense from my perspective.
But
The
it's not
Rocky Mountain Power has an overhead power line going through, or Weber Basin has their easement to go through. It's an easement. And the land developer can just simply say, I'm going to recognize the easement, abide by that easement, and sell the property accordingly to with that easement. That's one option. to go
Without
to.
amending the plat?
Without amending the plat.
Okay.
And what value is attached to that and the desirability of that market's going to dictate that from my standpoint.
Okay.
Let's say that they come to an agreement and the easement affects what they want to, the outcome of the subdivision is and their purpose for owning the property and dividing it. They could come in and amend the plat again. Now, you got to be careful about that. How many properties did you sell? You know, don't sell the ones that might be affected until you're really confident about it. It would be my private advice. That's not my opinion. I can't give that advice, but that would
Lot
be
sold, you
private.
probably have somebody
But
sign
it
on
would,
to a plat.
but you could re-subdivide the layout. And then that's a big question. That's probably the larger question is how much does it affect the layout that needs to be amended? And then we got to go back to and do the plat amendment and go through that process and make the findings. What was approved? How was it approved? What needs to be amended? And what's the process to amend it to a new layout?
So my second question is this. The ordinance says we state on the plat what is noted in the title report. The plat, as submitted thus far, says the purported easement areas 1 and 2 shown on the preliminary plat are claimed about it, or is hotly disputed, et cetera, et cetera.
Yeah, that's the preliminary, right? That's the preliminary part.
I've been looking at the wrong one.
The final now resets that and acknowledges what's on the title report.
Page is the final one. I'm sorry.
And so now you're looking at notation
Which
two
which
on
page
the
is that?
final.
I'm sorry.
Mackenzie has it on the screen.
What's that? Oh,
She has it on
Mackenzie's
the
got it
screen.
right there, right here.
So yeah, number two now says, the notice of claim of interest was recorded at the Davis County Recorder's Office on March 30th, 2021 as entry. There's the numbers, book, there's the numbers, page, there's the numbers. So they, and
Sorry.
that's the only thing on the title report that shows up as a record on the property.
Thank you. I didn't see what page that was at. Okay. Question answered.
I have a question about, so some easements, if his storyline of his first question goes through and it becomes an easement, some easements have conditions.
Mhm.
Who determines those conditions?
That's a great question. That's a great question, and this is why staff has played, in our best efforts, neutrality to what the code is. I realize there are people out there who disagree with me, but an easement is what's defined. You know, what type of easement it is. You know, is it for cattle to go through and back? You know, prescriptive. What was that defined? Date, time, what is it for? You know, the issue could be larger than that, proven that I've used it for X, Y, and Z for so long, and now that's my easement. So if it's a different type of easement, like a power line easement, you know, then it's defined for this use of power to this person for this purpose. And I think that's where we're at. What is the easement? What kind of easement is it? And that's been undefined and unperfected.
And who's responsible, if it comes to that, to define it?
That's why you have the court system. If two parties cannot
They-
agree to
they
the
would-
standards in terms of their,
A judge would just make a decision.
they have to go to the judge, argue their case of what type of easement they're trying to argue it as, and what the supportive evidence that supports that claim.
And then the judge would make a decision,
And then the judge would
or a
make a
finding or
decision.
something, okay. Okay.
If they couldn't reach an agreement. You always hope they can reach
But
an
if they
agreement.
reach an agreement, then everyone could just agree. Usually when you reach an agreement, it means no one's happy.
I can't really argue with that synopsis.
Maybe that should have been my thought.
Yeah, so, I'm gonna go home to my wife and repeat that quote.
Very cynical.
I'm pretty sure, like, I'm just thinking, you know, like, when you compromise, when you make a compromise and you reach an agreement, nobody's happy.
Just gonna tell her I'm still not happy. I agree with you, but I'm still not happy. Sorry, don't make light. That's a very important point. It was just funny.
Corey, on the notice of claim, because it just shows, and maybe I'm not familiar what a notice of interest actually is, but is there a legal description associated with that?
I don't, it's been a while since I've read that notice of claim. I think there are some descriptive language under that notice of claim in there.
Yeah, it has the whole history of the easements and title, but, you know, the land has changed. You know, they were different parcels, and some was split off, and some were combined, which also raises some issues of the doctrine of merger on the easement appurtenant. And so I think that, yeah,
What I'm getting at is if there was a legal description, would it not show up on the final plat? 'Cause you don't see it
right, because
here,
the title
correct?
company is saying it's not on the title report as an existing easement. It is in the interest of claim, yes.
Correct.
There
It's
are
not a-
legal
and it's not
descriptions of describing Drake's Lane. you
Right,
know,
they're
one rod
not
from this.
describing it on the title report as an easement, and as such, there is no definitive.
Right, so the notice of claim is
Legal
just saying,
description.
hey, we have this interest, we believe we have a right to these easements, and their arguments for,
Okay.
their legal arguments in support of their easement appurtenant, their easement by deed, and/or their prescriptive easement. They're making all of those claims.
But if I'm a prospective buyer, to Chair Daly's point, I don't know what that description is or which lots
Right,
that
they'd
claim
have to
of
look at-
interest would affect. So that's a challenge for me as a future buyer or a resident of the city to know, well, which lot does this claim against without a legal description?
Well, they could go, yeah, they could look at that notice of claim. I mean, if we, you
So
know,
why
if they
don't
look
we,
at it, or they're
if
realistic.
the requirement in the ordinance is that we show record, matters of record, and it shows up on the title report, are we saying that we don't know what the legal description is based off of all of these challenging, confusing factors?
Staff's position is that the prescriptive easement and the easement appurtenant has not been perfected, and it is not in the title report. Therefore, it is not existing and is not required under our ordinances to be shown on the final plat.
So, in this case, note number 2 talks about a notice of claim of interest. If I'm a prospective buyer, if I'm buying lot 127, for example, I would expect that something on my title report would say, here's an exception, notice of claim of interest. But if I'm buying lot 163, is that going to be the same thing? Is it still going to be on there?
Well, I guess you could say,
It might not even
you
show
know,
up on your
notice
first
of
one.
claim affecting lots 120 through 134.
That's, I think, what I'm
And
getting
then, because
at.
if I'm buying 120 and I see that, yes, that probably would give me more notice.
Because if I'm another title company underwriting the purchase of a lot,
Right.
I'm not gonna know that.
But at some point, the parties are either going to settle and/or to perfect or not perfect that. And that was the concern in the beginning is, at some point, that might not be true. You know, no, I guess notice of claim affecting 120 through 134. I suppose they could amend the plat to eliminate that.
And
if
that
they-
gets to my first question to Corey earlier, right? But if we don't note which lots those might affect, I think we're potentially harming future residents in our city.
And again, I think it's a substantial risk for the developer to sell any of those lots. Because they are then going to be sued by the person that bought it, you know, saying, you didn't tell me about this easement. I think it's
And I
a
think
risk
that's,
for them to
I think
take.
well, all that is reasonable logic. I think that's where I took issue with Commissioner Kerr a little bit. I don't think LUDMA extends that far. There are things that they're just saying, city, these are private matters, don't go outside your ordinance, stay within it. And even though you want to do something in a protective nature, which is reasonable to expect, it's the risk of the person selling the property.
And I'm not suggesting we go out of Lebanon.
No, I know
I'm
you're
suggesting we
not.
stay within our ordinance, which says you note matters of title, and this is a matter of
Yeah,
title.
And I think
But
you're.
it doesn't do a good job on the plat
I think you're,
specifying.
I think you're redefining it is appropriate discussion. I'm not trying to talk against
Yeah,
it.
okay.
Any other questions for staff? All right. We will now invite the applicant to come forward and address the staff report, any of the discussion items that we've had, answer some of the questions maybe that have been posed, and give us a rundown of expectations. If you'd introduce yourself, please.
Thank you. Does this mic work?
Yep, go ahead.
Loudly?
Yeah, you're fine.
Okay, thank you. Thank you for your time tonight. My name is Russ Wilson. I'm the land manager for Symphony Homes. I've got a few things to say, but then I'd like to reserve a little bit of time, if need be, for our legal counsel who's here with me. I'll start with this issue first, and then I'll move on to some of the lighter issues. Regarding the purported easement, of course, it's noted on our final plat. It will also, or it is also noted in our title report, and I'm also assuming that it will be noted in future title reports for lot owners. We're also going to provide a notice to our home buyers as well that exists. All of this, our position is that all of this may be essentially a non-issue if the easement is established by a subsequent court of law. It doesn't really impact the lots or conflict with anything. It doesn't impact the lot sizes, the lot widths, anything like that. I've actually got a thumb drive with me that I'm happy to share. We we've actually laid out homes on each of these lots, and even if the purported easement was established, all of our homes will fit within the buildable area outside of the easement area, and nothing else will be affected as far as the requirements and the plat requirements. So, if the easement is established, then essentially all that would be there is surface rights, rights to access, and that would, yeah, like has been explained, that would have to be established by a court of law. Are there any questions for me about that?
Yeah, I think, so, at least on the preliminary plat, it looks like the disputed easement area 2, that's got to run right through somebody's house on the 120, lot 120.
Lot 120,
Yeah,
right?
so.
And that's-
then- Anyway, go ahead.
Right, that's a separate, part of the same claim, but a separate claim for a prescriptive easement through that lot. So that would be a separate argument, and if that were established, then we would just agree to hold that lot out of the plat or make it, restrict it to being an unbuildable lot until that's figured out.
Also, I guess one of the maybe concerns I have with kind of what you're saying is, sure, for maybe the rest of those lots, it doesn't affect the home, but it could potentially affect any fences, trees, gardens, playhouses, whatever else, right?
Not as I understand it. I mean, they still own, the lot owner would still own all of that area, and I'll let Kevin weigh in on this, but my understanding is they would still be able to establish fences. Obviously, they'd have to provide gates for access, and they could use it. It would obviously also be used as an access as well.
Okay. All right.
Any other questions about that?
So let me make sure I'm understanding. So you said we will provide notice to our potential buyers of the claim of interest, and you intend to be bound by that?
Right.
Thank you.
Some of the other things, we really appreciate working with staff. We've gone through a lot of things over the past few months, and we're grateful for their time and their expertise. We agree. We've tried to be very thorough and very consistent to make sure everything is, all the boxes are checked and everything's buttoned up and matches the PDO approval that we received, as well as the preliminary plat. Corey mentioned most of these things, but we've made sure all the minimum lot widths and lot frontages are met. The building setbacks, as per what we received upon the PDO approval. Minimum building pad areas, all of the lots needed to meet a 2,000 square foot minimum, which they all do. The locations and the widths of the PUEs are all provided for. Lot addresses, street names, turnarounds, right-of-ways. We've worked with UDOT and received a permit for our connections to Main Street and the frontage road. As Corey mentioned, we've also got will serve letters from all the different utility companies, Weaver Basin. We've added their note on our plat. South Davis Sewer District, Rocky Mountain Power, Dominion Energy, and then the communications companies, Comcast, CenturyLink. We worked really hard with the city engineer to provide a drainage plan. That was, if you remember, that was one of the big concerns at the last meetings, is to ensure that we have a drainage plan that works and actually conveys water out of the subdivision. We've worked extensively with the city engineer to provide a surface drain system which has outlets on each one of our lots to convey surface water out of the subdivision. The way we are protecting that is through our HOA and our CCNRs, and we've submitted that with our application as well to ensure that those are owned and they're maintained by our homeowners association, and there will be a fee associated with that to ensure that it does get maintained successfully. The HOA would also be provided for the open space. We have some open space areas and detention basin areas as well that will need to be owned and maintained by them. Traffic studies, soils reports. Part of the drainage had to do with the soils report, so we've made sure we've met all the requirements of the soils engineer, as well as all the different requirements of the city engineer as well. Just trying to see if I've missed anything. That's all I have. Are there any questions for me?
I'm curious about your open space and what you plan to do with it, because you have some really weird spaces.
Right. So the lower section on the far.
Was there a landscape plan? Because I didn't see one.
No, there's no landscape plan on this one.
No, I just want there to be one.
So as far as usability, the use of the open space area on the west side of the development will be for detention, stormwater detention. And we've worked hard with the city engineer to make sure that meets the requirements of detention basins and stormwater runoff. There is another small open space area, I think it's labeled as parcel C right there. This has been a kind of a, at first we had it as part of that lot right there. But then we started to think it's a little, it's unusually shaped, and we thought it may be better holding on to it as kind of a buffer between that existing home and that existing lot there. So we're not making them a corner lot, but it becomes a buffer between them and our new subdivision, and we'd also look at putting an entrance monument to our subdivision there and landscaping that as well.
Any other questions?
I do. It's innocently asked, it's just, why all the fuss for one more lot? Why not design the subdivision so it provides access to the landlocked owner to the north? Why?
Our position is that there's, just like has been mentioned, that if there is an easement, that it should be perfected through a court of law. Prior to purchasing the property, we consulted with our title experts, title attorneys, and through all of their research, they didn't find that there was an easement that followed chain of title to be able to be provided.
Thanks.
Okay, thank you.
Thanks.
I have had the chance to appear before you a couple of times on video during the height of COVID, and I'm happy to be here this time not on video, in person, and to report that you're all much better looking in person. As good as you looked on video, you're even better looking in person. It's nice to be here. I don't have a lot of comments because Corey's done an excellent job, I think, of setting forth what the controlling principles are. The issues generally are, what is the scope of this hearing? And the scope is confined and limited by a code provision. And the provision essentially provides for three requirements, and Corey's set them out. The first is to have the preliminary plat compared with the final plat, make sure they're consistent. Secondly, to determine if the final plat is consistent with the requirements of the final plat, and Corey's gone through that both orally and in great detail. Can you hear me okay, by the way? Is that picking me up?
Yep.
He's done it orally and in great detail in his staff report, which I think is well done. The third issue that's presented in the scope of what you do is, if for any reason you would feel inclined not to recommend approval, you have to specify the specific provisions of the code that are not in compliance so that the property owner is aware of those and has the opportunity to try to rectify them. But Corey's not aware of any, we're not aware of any. We've tried very hard to work with the city to satisfy all of the requirements that the code sets forth, and the city's concluded, or at least staff has concluded, that we've done. We agree with the staff's recommendation, Corey's recommendation set forth in the staff report, that we have complied with the scope of your review, and that a positive recommendation is appropriate under the circumstances. Just a comment or two about the easements and the issue there. A question or two have been raised about risk. There is risk in going forward. We recognize that. We would rather have reached a settlement. We're still hopeful that this matter can be resolved. If not, then it will be litigated to make a conclusion. And in the meantime, we recognize that there's risk. The issues that have been raised with respect to these claimed easements, as has been discussed, do not affect every lot. They affect about 14 lots. And so the business plan, as I understand it, would be to proceed with the lots that aren't affected first, while we try to work out issues on those that are affected. And there's a reason for that. Both, I think it's just wise policy. There's another reason, and that is because of the issues with respect to the 14 or so lots that are impacted by claims of easement, the value of those lots wouldn't be as high as if those issues are resolved. And so the preference would be to first proceed with the lots that are not impacted, and there are plenty of those, and then proceed with the others as may be necessary if we can't resolve it amicably through settlement or through litigation. Another question has been asked about, well, what would the impact be to the back of those lots that are affected? And in the worst case scenario, if Symphony Homes were to lose on every issue, if we can't get it resolved first and we go to court, and if they were to lose on every issue with respect to this easement, and we don't think that will happen because we don't think they're valid issues or easements under the circumstances. But even if that were the case, the impact would be on the back of these 14 lots or so, with the exception of lot 20, which is more heavily impacted. On all of the other lots, it would be as if there were an alley between our property and the property next door. An alley that could be used jointly by the lot owners or by Mr. Packer under the scope of his use rights. And so that's the worst case position, but even then that would probably have a detrimental impact on the lot, although in this marketplace with an aging population, there is greater demand for lots that have less landscaping, less maintenance, et cetera, and so that would be kind of a silver lining. But that is an issue, and so because of those risks, Symphony Homes will be careful and wants to try to resolve things initially or litigate them if it has to. But just so you understand what the lots would look like, it would just be as if there's an alley at the back. And remember, I think the key thing to remember is Mr. Packer does not claim that he owns the title to any of that property. And so it's just a surface non-exclusive easement, which means that the property owner can use that property for any reasons they want that doesn't expressly conflict with the use of Mr. Packer if ultimately he would prevail. And so the size of the lots doesn't change. The shape of the lots doesn't change. The building envelope may be a bit smaller, maybe smaller on those 14 lots, but they're not so small that they're not developable. All of them still fall within the developability requirements of the code, with the exception potentially of lot 120. So I think that covers, I am in agreement with the conclusions, the analysis of the city.
So, thank you for that. That's very helpful. If you would, for the record, introduce yourself.
Oh, thank you. Thank you. My name's Kevin Anderson. I'm an attorney and representing or assisting Symphony Homes in connection with this matter.
Perfect. Thank you.
Okay?
Does anybody have any questions for Mr. Anderson?
Thank you. Thank you.
Thank you.
Chair Daly, can I just quickly summarize a response to Commissioner Shagrud's question?
Yep.
Long history to it. It's got several phases to it. Early in the beginning, before we, meaning the city, granted the PDO approval, our standard subdivision had two parameters that was discussed. And those parameters are, one, once you reach a 800-foot block distance, there ought to be a walkway. So that was discussed, and the walkway could go through the subdivision. A lot of it focused on getting a walkway to the school. And that resulted in the school district actually selling property and expanding it so that they wouldn't have that frontage. So the walkway was deemed during that process not necessary. The other one is it does go longer than our traditional block distance. So if you do look at our general plan and block distance, it is longer. But during that PDO process, the Planning Commission and the City Council discussed the need for some type of stub road, if you will, some type of mid-block someplace, so we don't exceed that block length, and where would it go? And the discussion of the Planning Commission, and also resulted at the City Council, is that the block lengths in this area are already long, and because it was a PDO, we could modify that block length with the approval. So I wouldn't call it an exchange, but in the discussion of connecting to the road, developing it all as one site, that was one area that was waived, was a stub road. And 400 West was deemed sufficient stub for future development. Not a lot of people, some people disagree with that, but that PDO decision was made at the rezone, so. And then there was, the third one is they did offer at some point in time to provide a small farm access. We're willing to, if they could reach the agreement with the party that was in dispute. They couldn't reach that agreement into the parties, so that 12-foot access disappeared.
Thanks, Corey. Anybody else have any questions for staff before we discuss amongst ourselves? Well, I'll go first with some thoughts real quickly, and then we can get right into, whatever motions we may entertain. I feel like this has been, honestly, a pretty, difficult topic from a lot of angles, for a lot of different reasons, actually, from my perspective. But I feel like after a lot of discussion, some back and forth, back to what I said earlier, where this is administrative, our job is to decide whether or not this complies with the code. Not whether or not we like it, not whether or not this is what we would do, but whether or not it complies with the code. And I in my own opinion, I feel like it does. Not to say that I think it's perfect or anything. I would certainly change some stuff on it, but that's not what we're here for in this stage of the process to do. So, yeah. Anybody else have any thoughts or comments?
I agree. I think they have taken, with the questions about acknowledging it and letting people know, I think they've taken that into consideration and letting them know the risks that they have for buying those plots. And I think that, and I agree that everything complies, that it's up to them to take that risk, not for us to minimize that.
My only comment goes back to our conditions of approval back during the preliminary and the ordinance itself relating to matters of title. This is a notice of interest. It's no longer noted as an easement on the title report, though the reason is an easement property is pertinent. My heartburn right now is that what we stated is that easements shall be clearly labeled and identified. There is a note on the final plat right now, but there is no identification on the lots themselves for any future staff member, any future home buyer, anybody that looks at this plat to know specifically which lots are affected by title. by the notice of interest as opposed to easement. But that's my frustration with this plat as it stands right now, is that it doesn't show the location of that matter of record that is noted in our ordinance, that matters of title should be shown there.
So for, I don't know, clarification or whatnot, but the last time we saw this, I think we talked a lot about conditions for approval. And those were conditions for approval for the preliminary plat, which now we're on the final plat.
Well, we said that, we asked the question of staff, will it be shown if it's on title? And the answer was yes. And so when I say shown, I'm thinking of a visual aid, not just a note on the plat.
And I'm happy to respond to that.
Okay. Go
So
ahead.
staff's position is that it doesn't meet the criteria of the code, which is show existing easements. It's not an existing easement, it is a notice of claim of interest.
Right, and that's where,
And so that's where we're
I'm
saying,
kind of, that's
if
where I'm
you-
conflicted, right?
But it's not an easement. So, I mean, there are a lot of legal descriptions in the notice of claim. And so it would be, I mean, I don't read legal descriptions, but, you know, you would have to look to that, and that's why it's problematic. But I'm not opposed to saying, you know, this notice of claim affects lot 120 through lot 134, and highlighting it for those owners.
I think that would be helpful.
Because I honestly don't know if there is a specific easement area or like prescriptive easements.
And not
you know.
only helpful, but I think complies with the ordinance in terms of what the ordinance states, at least my interpretation.
So you're not opposed then, Lisa, to a condition for approval to add that affecting lots 120 through 134?
On plat note number 2.
Okay.
And
Anyone
even
else?
as
Oh.
Commissioner Kerr had suggested, you know, requiring the developer to notify purchasers of those lots of that notice of claim, and perhaps even giving them a copy of it. And if you're considering conditions, I'm sorry to bring this up sooner, but a lot of the new developments that we're doing now are subject to providing a long-term storm drain facility maintenance plan. So all of the applications that have been coming through now, if they're over 1 acre, and they have to comply with the city's UPDES permit. So if you could just add a condition that the developer shall enter into a long-term stormwater facilities maintenance plan with the city if required under our permit. So I need to talk to our drainage supervisor and see if this is subject to that, and if it is, we'll have that ready when this goes to the city council. Or a
Okay.
condition.
Anyone else? Okay. Give me 1 second here.
Commissioner Kerr, no public feedback? Thank you.
Oh, it's fine.
Yep. I just wanted, love to hear everybody's opinion.
It's fine. All right, well, I'm going to make a motion real quick. As it is, we don't have any conditions for approval, so we'll be adding 2. Just 2, right? Your long-term storm drain development plan, and then the note. We're going to amend note 2.
And then if you wanted to add that the developer shall provide notice to those lot owners.
Were you also, well, are you going to bring up, Kevin, you brought it up in your comment about a no-build area, if you're going to provide access.
Well,
The applicant talked about providing access. Your question was related to playhouses, gardens, other trees, whatever. Are you going, if you have a vehicle, are you going to provide a true reasonable access?
I think at this point, though, the only thing that is reasonable to provide is a notice of claim of interest.
Because
of
it depends
easement.
on the
An eas-
definition of the easement.
Yeah, an easement hasn't been perfected.
Okay.
So, Okay. Just a second here, making a note. Claim of interest. Okay. I hereby make a motion for the Planning Commission to recommend approval of the final subdivision plat and plan for the Summerhill Lane subdivision to the City Council as submitted by the applicant to the commission with the following conditions. Number one, the developer shall enter into a long-term storm drain development plan.
Stormwater
Facilities management plan, sorry. I can't-
Hey, I had the problem 2 weeks ago. I'll help you out.
It's
If,
required. under
if
the
required,
city
if
permit.
applicable.
If applicable. Great. Anything else we need to say on that one, Lisa?
No, that's
Okay.
adequate.
Condition number 2, that the applicant shall add affecting lots 120 through 134 to plat note number 2 on the final plat. Is that good for you? And number 3, that the developer shall provide notice of claim of interest to potential purchasers of lots 120 through 134, with suggested reasons for action A through D as listed in the staff report.
I'll second.
Thanks. Okay. We have a motion and a second. Any further discussion about the motion on the table? Okay, we will start at this end.
Aye.
Aye.
Aye?
Aye.
Nay.
Lisa, is abstention allowed under our planning commission?
I prefer not under Robert's rules, just unless you have a conflict, but if, commissioners have abstained,
We would have a quorum with 5, correct?
yes.
And 4 would pass, correct? I will abstain.
Okay, thank you.
Chair Daley, can I address the applicant in public?
You bet.
Just to reiterate, this goes to the city council. We will prepare tomorrow a report to the city council. You can contact the city recorder, date for agenda with the city council. And the city council does hold a public hearing on this. So be prepared with your presence at the meeting if anybody wants to present anything. And also, please provide the written comments well in advance of the meeting. You want to provide written comments. It's difficult for staff to take a 5 o'clock hour. So we publish by the afternoon on Friday. So if you'd like some written comments presented to the commission or to the city council, please provide them the Thursday before, right? Thursday before. And then from there, the council will decide what they do with further public hearing and comments. But look for that on the agenda, and it will be a public hearing.
Thank you, Corey. Okay, we will proceed now to the next item on our agenda, which is also administrative decision. This is for a final site plan for the pastures, Phase 3. And we'll turn the time over to Mackenzie on this one.
Thank you, Chair Daley and members of the commission. So this item is part 2 of the site plan process. The pastures in the Shorelands Commerce Park.
Mackenzie, time out. Is your microphone on? You are
Okay.
particularly difficult to hear.
I'll turn myself up, okay? Can you hear me now?
That sounds better.
Is that better?
Yeah,
Okay. The mask probably doesn't help.
probably.
Okay, now I can hear myself, all right. That's weird.
Yeah, it's weird, but let's go with it.
Okay, so this is part 2 of the site plan process. As mentioned, it's a administrative decision. It doesn't go beyond the planning commission. In April, the applicant brought the conceptual site plan forward with the 4 conditions. for final site plan. Staff is of the opinion that he doesn't meet several of those conditions, namely irrigation and landscaping. And the applicant can argue that as he wishes. But one thing noticed in review of the whole site was parking. In the previous staff report and approval, staff just based their parking off of the provided 20% office space, 80% warehousing. But with a closer review of actual tenants, that is not the makeup of the uses in this whole site. The two current buildings, I've left it as 20% office, 80% in building number 3. But the table in the staff report depicts the current uses. It doesn't actually address building number 3. And so with the current uses and current occupants, there is not enough parking per code to even cover the 2 buildings, let alone allow for a 3rd building that would add parking to the site. So it is staff's recommendation that we table this item so that the applicant can address the landscape irrigation, specifically for the Shorelands Commerce Park, which is natural landscaping, so it kind of blends in with the legacy preserve, but specifically irrigation so that it is maintained, so it starts and thrives, but maybe not a long-term irrigation plan, just so that those materials can take root. And also to give the applicant a chance to either do a parking study or to apply for a parking modification to address the current parking situation, because as is, there is not enough parking for an additional 3rd building. So if you have any questions, I'm happy to answer
Chair Daly,
them.
could I just address the parking issue?
Yeah.
Yeah, I think, I talked with Mr. Salmon earlier, what was it, yesterday, Mr. Salmon, we talked about parking issue. This is the continued adage problem of what you're doing your parking study update for. Flex space will predominantly entertain warehousing, which is that's a terrible term, low bar for parking. It's 1 per 1,000 square feet. And so you get these small offices and large warehouse stuff. And flex space is designed to be flexible. But our parking, depending on your use, can change quite dramatically. So our parking study tangent is going to look at what the first set of bank of square footage of flex space you build will probably be a little different calculator than subsequent, like the first 10,000 or the first 15,000 or whatnot. So we hope to fix that. But we have problems with this association as it comes in as a warehouse office space, and then different tenants come in, which are also allowed in the IH zone. In the case, I think we're dealing with a couple of dance studios, and they actually require a lot of parking. Mr. Salmon, it is his belief that some of those numbers don't necessarily reflect actuality, and I couldn't 100% disagree with him, because we do kind of have this baseline, object is we can't cover everybody, and we can't cover In-N-Out Burger and then Corey's Taco Restaurant. There's going to be 2 different sets of parking, based on my cooking skills. And so we do have these baseline areas that we shoot from, but there is a parking modification, and there's a couple of ways of adjusting it. One is for your use. You might be categorized as this use, but your actual operation and so forth doesn't require that demand. They can seek the Planning Commission approval to look at a specific use and just do it based on that use. Sometimes that's problematic, because if that use only lasts 6 months and something replaces it, it can get kind of dicey. So that's not necessarily the best way, but we've done it. So you think the All Seasons Spa on the frontage road, that's the way I refer to it. It changed to a graphics design studio, and they didn't need as much parking, so they wanted to lease a portion of the building out, and we had to look at a use differentiation, their use and the other use, and came up with a modification. Another place you can do it is when you share the uses. So this is the simple way is nighttime use of residential, daytime use of office. Don't need to have 2 sets of parking stalls when they're off-peak hours. And you look at the Megaplex Theater, that office space Megaplex is in that mixed-use kind of shared scenario. The third one is that just to have fun, your parking tables are crazy. I don't know where you got them. You got them from Fargo, North Dakota. And I want to do a parking study and modify the uses, and we're going to go in and look at the institute a parking manual, come up with the appropriate set of numbers, and assign it accordingly. So I've talked about that with Mr. Craig Salmon, and I was going to call him Mr. Craig. I tell him Mr. Craig, and I think we might be somewhat in that scenario. The only cautionary tale that I discussed is if we do a shared use with like a dance studio, that dance studio goes out in a few months, and you want to replace it with a daytime user, and that demand's high. Once again, we have that flex space problem. So I don't know which way Mr. Craig would like to go with it, but we do need to resolve the banking issue of all the parking and then getting to a place that is underparked.
So Corey, my question for you then is, we're looking at a final site plan for phase 3. Are we talking about just this third building, or are we talking about the whole?
The whole development.
The whole development is
Yeah.
up for
McKinsey,
discussion.
because it's all one project,
Yep,
and so McKinsey did look at what's licensed in there
Yep.
and what was built, and we're using up that bank. So if we add another building, we're out of bank space.
so Mackenzie, in your table, you have provided 117 stalls. That's for the whole project.
That's for the whole project.
Okay. So I asked those questions partly because I want to make sure that we are not punishing the applicant for previous short-sightedness of staff, or not staff, but
Go ahead, so staff.
It's fine.
planning commission or city council or whatnot. But we are, like, it's fair to talk about the whole thing here, not
It's all one project, so they have to add parking, and based on availability of parking and a new building square footage, we're having a problem with the banking problem. What's this new building to be used for? How do we define it? You're gonna provide, obviously, some parking, but now it's spilling over into other parking areas,
Yeah.
and that bank is used up.
But to play devil's advocate with this one, if we go back and just count it all as that warehouse space, small office, large warehouse, for the 3 buildings, is there enough parking?
Yes.
There is, but now that we look at more closely,
Well, we look at it at the business license level, is where we capture all of this. We will look at it and say, oh, this is not an office use, nor it's a warehouse use, but it's allowed in the IH zone. Then we talk with the applicant. So an example is the Parish Creek Park with the Coconut Grove Playhouse, and that was slated for office, a small office, large warehouse. And we're getting some different uses in there that are allowed in the IH zone. So what staff does at the business license level is says, okay, you're allowed, but now your risk is you're using up your bank of parking. And once you hit that, we don't approve any more business licenses. And what McKinsey's is doing is saying, hey, we're adding a third building. Let's not wait till business license. Let's address that now.
is that fair to the applicant that we didn't do that when we built buildings 1 or 2?
Well, the fairness would be is that you were approved for office, small office warehouse. We're not going to give you a business license for anything else until you go amend your site plan.
Okay.
And I think that kind of goes back to 2 of my thoughts. To Young Power Sports was, hey, we want to see your plan. If you're going to say that you only need parking based off of these types of uses in your project, let's see a plan. And if you change that plan within your buildings, then we can talk about parking. And the Coconut Grove, we talked about this, year and a half ago, where I made the argument, hey, look, we shouldn't be in the business of telling an owner, a private property owner, how they utilize their space, whether they want to use it for flex or office or retail, that's up to them. And if they want to have space vacant, let alone occupied, in order to satisfy some parking requirements to get another tenant in, I don't think that's our business. I actually like this table that's been provided because it kind of keeps the whole parking issue front and center and frankly honest with our ordinance.
Tell me about parking study.
Yeah,
Could the parking study tell me, could you hire somebody to go sit there 24/7 for 7 days and tell me do we actually have a
Yeah.
problem?
Yeah, and that starts going on that use issue. What are the uses that are going on, and let's do
'Cause
an
I-
actual study of what's happening. So that's one way of approaching it.
I happen to drive here 5 days a week. And,
Go to True Golf, right?
yep. And it's not so much as a parking problem that I don't even see it as a problem. Like, there's plenty of parking behind the buildings. Nobody parks back there. They're empty. And the issue or the congestion comes 15 minutes when class is out.
It's
And
the
all the
queuing.
parents line up.
Queuing, right?
And so what? Who cares? For 15 minutes, it's crowded, big deal, and then everybody goes on their merry way. Like, I just don't actually think some of the, I don't think a dance studio needs 31 stalls. I don't think Conte Karate needs 64 stalls.
You're looking at the pragmatic world,
I'm
and,
just saying.
and I'm not saying the baselines, the baselines are trying to cover a broad spectrum of potential users and potential impacts, so
Yeah.
they're not scientifically proven to be true. That's why we have the modification. Now, you're making the argument that Mr. Craig, for lack of better terms I've defined tonight, says, well, Corey, this is a practical. Why can't you as a zoning administrator just look at the practicality? I'm more like a daycare at the dance center than I am people sit and park and stay, except for the recitals. But the ordinance doesn't let the zoning administrator make that discretion. All of the parking discretion is reserved for the planning commission.
And I think to Commissioner Shagrood's point is we have the opportunity at this parking update to address those types of issues in our recommendation to the council related to what are we going to require for these types of uses.
Yeah, my hope is a parking study will do a baseline that doesn't go on 2 square feet of office and 50,000 square feet. We have a base, and then when you rent out to different tenants, we've got some banking. But I can go a step further. Why should we worry about parking?
I'm saying,
Well-
Target's always empty. Black
So-
Friday, it's never full. Kohl's.
There is a
Home
planning
Depot's never
argument to
full.
put more square footage of building space down because that's economically more efficient for everybody than to build expansive parking lots. So-
Except that we have an ordinance in place and you have to abide by the ordinance
Well, and
regardless
also,
of if we disagree with it or not.
except that we haven't planned for significant on-street parking, and so.
Well, that's my follow-up question. Can you park on the street down there? Can he count on street? And all the spaces available on that fun street?
That's addressed. On-street parking is specifically called out. You cannot use it towards your parking count. Off-site parking, available within 500 feet, can be part of your parking calculation.
What's the definition of off-site parking in this case then?
Using Home Depot, the
A
Target.
neighboring parking.
Well, in this
But
specific.
In this
in
case,
the application, the construction they got
okay.
under.
They don't
the-
have, yeah,
There's
they
nothing
go
out
over to
there.
Cook's and see if he's got enough parking, which I
Well, they're
doubt.
building a building to the west. They're gonna have a parking lot.
To the west, yeah, that's the Cook building, to the
Okay,
west of
so
this.
you can,
Well,
But they have their
listen,
parking.
That's not done yet.
I think shared parking agreements are messy and less.
do we have to have a physical agreement to do that and count it? Oh.
Yeah, we did that with the Bridge Community Church.
Yep.
Rehabbed a former O'Brien Glass building, didn't have a lot of parking because it was manufacturing and warehousing. The Assembly has a higher demand, and so they used surrounding spaces that were access to some of the warehousing and have agreements with them. And that would be an off-site parking.
Mackenzie, question for you on your table.
Yes.
Building number 2, suites 2 and 3 are listed as vacant, but especially suite number, okay, well, 3 is combined with 4 and 5, got that.
Right.
But suite number 2, is that actually part of suite 1, or why did we put vacant down and put it as one of the most parking intensive uses as personal instruction?
Right, because that was what was there previously, before it became vacant, so that's the last license I have available.
Why wouldn't it
And
go
that was-
back into
That was
bank?
what, the tenant finish was for
That's gonna
a
take my daughter to dance.
personal instruction use.
The tenant finishes personal instruction, and that's why we did that instead of going back to
Right.
the base.
It could just be 4 parking stalls.
But, okay, but I mean, the
But
point
the-
is, that's
the
still not gonna get us
permit,
anywhere
yeah.
close to closing the 170,
Right,
well, whatever, parking stall gap. that
Right.
we've got.
yeah. And you'll probably notice that my table doesn't include building number 3. So this is just for the two tables currently there.
Right, and that's why I asked you the question about the 117, that does include table, or building 3, but we are not even including any required
Parking for that building.
parking
right.
for that building. So we'd be up over 300 required stalls then, probably, whatever.
Right, let's see. If it was just strictly warehouse, it would only need 8 stalls. But
If it was,
if if building 3 was strictly warehouse, it would only need an additional 8 stalls.
Oh, 8.
Yeah, but that's if it was just warehouse. So it could take us over to 300, yes, depending on the use.
Sorry, your point is, we have included 3, it's just been combined with the others.
Can I answer some questions, I think? will help?
We'll get there in just a
We're
minute, hang
not
on just a
to
second.
the applicant
We'll,
yet.
we'll get to you in just 1 second, so hang on, yeah. Okay, do we have any other questions for staff? That's the stage of the discussion that we're in, is to ask staff questions. Oh, yeah.
So, Mackenzie, I just want to make sure I'm understanding why something was done the way it was done. So the applicant resent the Army Corps of Engineer letter from 2011, but not a verification as was required in our last.
Right, so that is
go.
an additional reason why I think it should be tabled.
But I just want to make sure the planning staff recommendations don't include anything in that regard. Why? I'm just curious.
I have no reason for that.
No worries. I was thinking of adding it. I wanted to make sure I wasn't
Yeah,
missing it.
you're right.
Okay. All right, any other questions for staff? Okay, now we'll invite the applicant to come up and address any of the things that we've talked about. Anything else from the staff report? If you'd introduce yourself, please.
Okay. My name's Craig Salmon. I live in Centerville, and I've had my business in Centerville for 35 years, I guess. And so we're on the west side. And I have built several buildings in Centerville and sold some, and then we, obviously we keep our own development now, and we lease out space. And I've worked with Corey over the years and extensively over the last 20 years. How long have you been here?
18.
Okay. To answer your question on the Army Corps of Engineers, we submitted that letter. I don't know if you've ever dealt with the Army Corps of Engineers, but it's insane. But we have dealt with them. We have not changed anything, and we can document that, and maybe the city has looked at. We haven't changed anything with the wetlands affecting it, what we had based on that letter. So it stays intact, what we've done. We're not changing it or altering it. It's staying intact. We have delineation lines where the wetlands are on our maps and plans, and we're not intruding on those. Secondly, about the parking. I talked to Corey, and I think that this could be really solved more efficiently if he had the authority to sit down with the developer and say, okay, now you got this business in here, and I'll give you an example. Salmon HVAC, we have 3 suites. We got, roughly 14,500 square feet. Well, we're listed on our business license as a construction specialty contractor. Well, if you take that parking load for that, it's 1 per 250 square feet. Well, it's insane. We don't have that. So I asked him, okay, we'll take the office area at that number, which is fine. Let us have all the rest of it as manufacturing or warehouse, which is 1 per 1,000. Now we're talking more realistic. And that's what I have based my new calculation, and you have that, right, Mackenzie? And I don't know if you have it to show them, but I based my new calculation. So for Salmon HVAC, we are now at roughly 20.4 parking stalls. We don't even use that many, but that's what it is. I mean, that's the best scenario, and it's still ample for us, but it's still not even close to what's on, that was maybe forced to put, he said he had to force it because he didn't have the power to override it, which was 57 for Salmon HVAC. 20 roughly versus 57. So that issue is on every space. And some of the spaces you guys didn't know that have been released. True Golf is not there anymore. And we've leased it out to a company that does warehousing and supplying computer parts and selling copy machines, that type of thing, but they don't have retail there. They say wholesale, they go out and sell. They don't have public come in and they're not demonstrating and all that. But, so my point with them again is we had, we listed it as retail, 1 per 250. That's not fair. That's fair for their office space, but it's not fair for the warehouse or manufacturing. So that's what I've done, is gone through and broke them out, showing the correct classifications that we feel were. And I said, well, Corey, why don't you and I just sit down and this is common sense. Why can't we come up with work through this instead of, it ain't gonna work, and now I gotta submit a request to you guys to do an addendum, and I mean, oh my gosh, it's just like, what reality is, and if he doesn't agree with the reality, we both agree, then I guess we come to you and ask, what the reality is. That's just a suggestion I have. The other thing that I talked to Corey about was having the shared use. Now, my mind is shared use, is that whole complex down there is shared use. I'm not sharing with Cooks across the road. I'm not sharing with any other property owner. That is our property. And we have all different kinds of businesses. We're sharing the parking. Okay, we have 117 parking stalls. And based on my number using, in my mind, the correct calculation, we need 110. And that's even with the new building. And that's not all warehouse. I've classified some of it as office office, and some of it as storage, manufacturing, or warehouse. And so that's how I come up with the 110 that we feel like we need, which still were below our count. Now, as far as the Kona Karate and the dance project move, they call themselves, we feel, number one, it's a different, if you did personal instruction, which is more like a workout place where people have driver's license and they drive there and they come in, they park their car and they work out. Well, that's not what these are. These are all, I said juvenile, I don't mean juvenile delinquents, I mean juvenile kids come and their parents drop them off, and they usually come back, in an hour, hour and a half, whatever, and pick them back up. And there's a line. I mean, they drop them off and they pick back up, an hour and a half later or whatever it is. And they start at 5 o'clock, roughly 4 o'clock to 5. By that time, a lot of the people in our development there have gone home. And to share with you some numbers, I kept track of it this week. At 2:35 p.m., 45 people, 45 parking stalls. Again, we have 117. 4:30 was 64. That was the highest number I had in the last 3 days, was 64. 6:30 was 38. The next day, 35, 41, and 37. And the next day, today, 54 in the morning, 41 and 37. So, and I mean, these are my numbers. I didn't fudge them. I just want there to be reality. I don't want a parking problem down there. By far, I don't want it. You know what I mean? We have to be able to function with our business down there, which is we're the biggest, occupier of the space. And I don't want parking. I mean, I know you guys hear that probably from everybody you talk to, but the reality is we don't need 200 and something parking stalls. There's absolutely no way. Now, if we were, those were personal instruction company and they were there, everybody had to drive there to work out, we could have a problem. I'm not disagreeing with that. But these are places where they come, they bring their kids. Now, only time I've ever seen our parking lot full, was on a Saturday, and they're having a Kona Karate meet, fight meet or whatever they call it, I don't know. And they do it on a Saturday. We specifically asked them to do it on a Saturday when all the other businesses are not there. And I have seen that happen before. Once a year it happens. But so I guess my point is I'm asking for a shared use, and you guys have the latitude to do that. I don't really want to do a traffic study. I got to hire somebody from North Dakota or wherever you're saying to do it. I don't think it's just common sense. And if hire Corey to go down and count the cars.
He's not available for hire.
It's expensive.
But anyway, that's my spiel. So we feel like we're adequate. We've given account with that 110 on building 3, which was 11 people actually. in our count. And that's, again, plenty enough using the table that I'm asking to be able to use with so much office, so much warehouse, and manufacturing.
So Chair Daley, I think there's two issues here that I think need to be discussed and see which the venue for resolving is. The first one is the statement that I don't use at all is 250 square feet of similar to retail for my HVAC business. Granted, we're talking about that with the young power sports. You know, if the applicant can show, okay, this tenant is this much warehouse and this much space, and we've got that listing going on, because once you start changing tenants, you know, it gets much more difficult to start tracking, because if it's a dance studio like McKinsey, it's vacant, but our records, dance studio can come in tomorrow and open it back up, so we don't count it as vacant in our mind until we know who a new tenant is going to be. So I think there's one thing is to just see how the numbers work out based on the actual use, because I agree that if it's only a small office and warehouse, if we can distinguish those square footage, we do that calculation. And if we can get into the number that allows the third building to go in, I don't think there's a big issue with it. However, I do have a little bit of concern on the issue of how the operation of one type of user at a dance studio operates and another user might, and I would be uncomfortable without a parking modification and a specific use study or whatever is needed to the commission to borrow those stalls based on it really acts like a daycare, not what's in your category. That is where I say, yeah, that's where the study needs to come in. So I think the first one is find out all those uses, we'll check all those tables. If we can come to the right amount of parking stalls with the addition, sure, we can come back to you with the site plan and say the capacity's there, and we just have to track with that record who's going in and going out and back to the banking program if there's any future changes. But at least we have capacity at a snapshot in time. If we want to change the need for a specific use to get to that number, that's when we need to bring the parking modification back to the commission.
But why, my question is, why can't they give you the power to sit down and I say logically, this is not a personal care center, personal instruction, but it's also not a daycare, but it acts like a daycare.
You're talking to a planner that nobody feels is reasonable.
The short answer to your question is because the zoning code, as adopted by the city council, does not give him permission to do that. It says specifically that the planning commission may modify the number of parking spaces. So Corey can't do it.
Right.
You need to talk to the city council to change his ability to change that, which I would be opposed to you doing it if you wanted to do that.
Well, it just seems like it'd save a lot of hassle.
Sure.
If somebody, with a developer like Corey and say, we give our reasoning, well, that makes sense, or it don't make sense. If it don't make sense, then you deny it. Okay, one other thing, just to clarify. She had some spaces empty, they're all full. Okay, so where Alpha Graphics was,
Okay.
Logo Concept is now renting it, and it's all manufacturing warehouse. That's what they categorize it to.
They've combined those two
Yeah.
suites?
Yeah, well, yes, that's right.
Do they have a business license?
Well, they have a business license, of course they do.
I will
But they don't
just
probably
say-
have that square footage set.
I
So-
will say to the applicant, you see how
absolutely.
complicated this is because
Yeah.
staff is trying to track real time, but trying to respond back by ordinance to
Right.
the entities in the city government to try and manage the code.
And the dance people had one 4,000 suite, now they have two. They've taken over Wasatch CrossFit where they were to be, and now they've taken that whole space over. And it's even better now because of them, because Wasatch CrossFit has people that drive there and stay, and these people don't. They have, and that classification lets you have one parking stall per 500 kids, I guess is which really makes sense. It's actually perfect. It works perfect.
Okay. Does anybody else have is there anything else you'd like to?
No, if you have any questions for me.
Yeah, does anybody else have any questions for the applicant? Yes.
So I'd like to understand a little bit better your position regarding the engineering letter from the Army Corps, and I be the first to admit, it's gonna take you about 10 or 15 years to get any response.
Yeah.
No doubt there. So you acquired property subsequent to your 2011 letter from the Army Corps, is that correct?
Yes, that's right.
And so the project that was sent to the Army Corps for their review doesn't include that additional property, nor does it include the new configuration for Building 3, is that correct?
That's true. That is true.
And that, I wanted to make sure I'm not misunderstanding that, because when you said earlier nothing's changed, I was a
Okay,
little
well, let me
confused.
clarify that.
Okay.
So that little piece that we bought from them.
Well, from
that pe-
UDOT, right?
That from UDOT, that's exactly right. That little piece was not, some of that was not in the wetlands, and it's still not in the wetlands. Okay? There is a ditch that goes through there. And that ditch is part of the wetland. It always has been, and so what I mean by that, nothing's changed to the wetland delineation.
Okay, I think I understand. Have you started the Army Corps process to get an updated letter?
No,
And why did you choose to not do that?
because we didn't change anything with it.
But we told you to do that on April 28th.
I know, but when I told them, I says, well, nothing's changed with it. So nothing has changed. I mean, they can see the map, and we have shown the map, and nothing has changed with the map, so why would we want a letter?
Because,
We required it.
okay,
That's only my only point.
I understand.
If nothing has changed with it, with the delineation, like we're encroaching on the wetlands more or whatever, or into the wetlands, I shouldn't say, if we're going into it, then I would say, yeah, we have to have a letter, but, I mean, you can see the map, so and on our new proposal with that building is not touching it. So, that's why.
Anybody else? Any questions for the applicant? Perfect. Thank you.
Okay, thank you.
All right. Does anybody have any other questions for staff? Go ahead, Spencer.
Just, Corey, we want to try and be as accommodating within the ordinance as possible. We want to comply with the ordinance, but in the case of parking, if there is a practical argument to allow them to share uses or
Multiple uses in the same building.
yeah, multiple uses, hours of operation, ages of individuals visiting, what flexibility in the code are we given as a planning commission?
As a planning commission, really broad on the modification, and that has been some of the angst of the commission, is the issue of how many times people have come in for a modification. Now, I don't have as much concern because I think there is this baseline that we work of, and we can modify it. The question is how much latitude of modification are you comfortable with? So, yeah, but yeah, you could base it on hours of operation, you could base it on the shared, you can base it on mixed use with it. I think the mixture within the same project is pretty easier, because if somebody's really devoting just to warehouse, we can track that. When the next tenant comes in and it's a dance studio, we'll go bing, 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 that's gonna change from a warehouse. But somebody who declared it warehouse and then expands the operation into that warehouse, we're probably not gonna get till complaints arrive.
That's kind of what I'm also, like, what flexibility do we have, but also from an implementation and enforcement, what can we do to make sure it's easily trackable for you as staff, but also for the applicant, so that they have a clear procedure. So for Young Power Sports in the future, if they want to change their parking, they just bring in a new plan that shows their different types of uses, a parking table. I don't see this as much different, except that they've got a lot of tenants coming in and out. So the issue for an applicant, if they want to have a parking modification, that's great, but they're subject to applicant and public notice, whatever, getting on an agenda, whatever else that might be. So that gets it a little difficult from a leasing perspective, from a business perspective. I don't know that I have the right answer, except that.
Well, yeah, I think without a specific modification, your flexibility is understanding uses of the structure and assigning the parking demand accordingly. And then this is the problem with flex place. If it's all listed as warehouse, it's an implementation problem when somebody wants to do a different use.
And by my notes, this is messy right now.
Your notes are missing.
But I,
Yes,
my
I
my
know.
first, my
Because
fir-
I'm trying to keep track, well, this actually not vacant, and this is a different.
Right,
And
but
that's-
those are the arguments that the applicant needs to make under a parking modification.
That's,
So if you
that's
go to
what I'm
section
getting at.
1252-110.
Yes.
Those are the standards for a parking modification.
Yes.
It's not what the applicant wants or what's practical. Our code requires parking spaces. If you want to change that, you go to the city council and have a legislative change, which we're working on. 'Cause
Correct.
We
Yep.
know we're overparked. But right now, Corey and the planning commission do not have the authority to alter our parking requirements. The only authority is under 1252-110 for a parking modification.
So, Lisa, can I ask you about that? Right, 'cause that was
but
a
we do
question.
have one flexibility.
And that's what I'm
is
getting
Well,
at.
in
is-
determining the uses,
Yeah.
yes, in the building.
Yes.
Multiple
right.
uses in a building can
We
be
have some
calculated
flexibility, but
according to those
confined
uses.
within the ordinance.
Right. I do agree, yes.
Corey, could you repeat that? Yeah, go ahead.
Multiple uses in a development, one site development, if there's multiple uses in a building or multiple uses in several buildings, you can, our ordinance does say you can calculate it against what the actual building's being used for. So an example back is Young Power Sports. They're gonna have a repair shop, they're gonna have a warehouse and parts storage area, they're going to have a dealership area.
Or the applicant's argument that part of this space in spaces 4 and 5 of building 2 are used mostly for warehousing and manufacturing.
But
so,
sometimes,
but wait.
it can just be a guessing game, because when they
Correct.
build
No.
it, and so this is the developer's decision. If they say flex space, they will be underparked for most other uses.
Right, and what I'm suggesting is that if they were going to apply for a parking modification, fine, if you're going to say that you're using some of this for warehouse versus office, show us.
Yes.
On a plan.
Yes.
Something that's documented for us to
Yes.
see as a commission that we can rely on and go back from an enforcement provision and say, wait a second, you said on this plan dated such and such that you're going to be using these uses and it's not in compliance with that.
Yeah, so that's kind of my question, Lisa and Corey, I guess, whoever. For that parking modification, the applicant must request a parking modification. Is that a separate application?
Yes.
It
It's a
is
separate application.
process.
separate fee and
Separate fee?
Separate fee,
Okay.
everything.
Just so I understand that, though, is it when they, say a tenant turns over, they go in for a business license, is that what triggers that process?
no, it's
Well-
usually a permit for modifications
building
within the, building permit.
Yeah,
Because, for example, the applicant stated a tenant had changed but did not request a new building permit, and so we can't track that easily what that use is without just starting over and tracking all the tenants
The
all the time.
permit for the
on it.
tenant improvement you're
Yeah.
talking about? Yeah.
As opposed to.
But there's also at the business license, late into the process, when somebody converts a tenant space, the business license comes in, says, I want to go into this tenant space, and it's going from warehouse to a dance studio. That's what triggers it also. So it's caught in the bill, it's caught at site plan. What are you saying your uses are going to be? But then we look at the building permit and the tenant finish, and very often, the tenant finish is changing. And then once the tenant finish is done, then you just get the changes at the business license levels.
So, okay, so in my own personal opinion, and I'm not speaking for the commission in any way, but my own personal opinion here, the applicant has two options. One, apply for a parking modification, which I feel like there's probably decent grounds for, at least we can talk about it. Or two, option number two is wait until we complete our parking ordinance review, which might take months, and that's probably not ideal either, but.
Or three, with the final site plan, address all of the suites and user counts. So we've got the correct snapshot. And, because I don't want to.
Or a combination of 1 and 3.
Yeah, or a combination of 1 and 3, because I don't want to take away the opportunity to define that if I have multiple uses in a building, I can calculate those multiple
Because
uses.
to Heidi's point, he could have a parking study done that says, we're really queuing, we're not parking, and he could substantiate that as a fact of finding as part of Lisa's
Yes, and then
instruction
that
to
would-
us.
And then that's for
that
that
would be-
specific use.
That's
So-
exactly right.
Well, Corey, how is that different than the parking tabulation on page 9 of the civil plans?
Is a parking
It's
study usually
that.
stamped by an engineer?
No, this parking tabulation is similar to what you required the power sports to do.
Well, I know, but you said, or the applicant can go back and update the site plan to include the uses. Well, isn't that what that is?
Yeah, and if it meets, and if we haven't had a chance to review it.
Well, that's not true.
Well, I haven't had a
So-
chance to review it.
Love it.
So
Half
they
of
don't,
staff has.
yeah, the uses listed in this parking tabulation do not match the business license uses.
Okay, that's where
So they
the,
don't match what our code requires of the current tenants.
So our
That's because they've changed.
code requires
No, I think it's more, he's calling recreation entertainment, which is actually a personal instruction service. So Kona Karate is being called recreation and entertainment, which has a lower parking requirement than what the code calls Kona Karate.
that's why I'm saying he could go back to this tabulation, correct it to our definitions, see where we're at. And it may get him there, it may not get him there to that point. And then once we know what's actual uses, what the actual tabulation categorization is, we have the number, then we can start working whether we need to go to a shared parking or a
Modification.
parking study based on use, something of that nature.
Okay.
I just don't want to steal the opportunity that if somebody's really doing warehouse, they get counted against warehouse. I agree with McKinsey, if it's recreation and entertainment, which is a lesser amount, but it's not categorized under our code as recreation and entertainment, then it can't count.
Does a parking modification give the commission broad flexibility in determining ages of
Yes,
occupants? Okay.
you can count the user, specific user, their hours of operation, their shifts, all of
Great.
that nature.
Yeah, hours of operation, estimated trade-off between businesses which are open and closed. It says car or van pooling programs available, but I would include that.
You can even
Neighborhood,
include, you can even include transit users.
transportation alternatives.
Yep.
Yep, so, anyway.
Can I ask a question?
Well, hold on a second. Is anybody opposed to hearing from the applicant again? Nope, okay, go
I
ahead.
just want to be clear. So are you saying that you can do this before we submit this thing, or is this part of the modification?
No, we calculate your actual uses based on city categories and the required amount and see where we're at.
Okay, my question, the one that's a gray area, the dance and the Kona Karate. There is not a category that fits them.
Well, there is personal construction, because that's what they are under our
Nope.
definition.
But you could ask
Personal
for a
instruction.
modification.
But then
within
after
that.
modification
I
for
said
that, so we have
construction, I probably
to,
did.
so in other words, we really do got to go through the modification.
Well, I guess you could
think it
try and see if
I
what
think it
they,
benefits you, yes.
I think you could try and see if what's on that table could fit within the correct
Which I
categories as
used.
defined.
Daycare, you know what I mean, and you would agree with that, wouldn't you?
Well, I'm not arguing that the queuing isn't similar to a daycare, but our classification,
Sure, but it,
Not
Says
personal
different.
instruction, yeah.
but the uses need to match what it's defined as, which in this case, that type of stuff is a personal instruction. So you could do it that way, and that would avoid the parking modification, right?
if you can get there.
If you can get there. And if not, the parking modification opens up a lot more
Yeah.
freedom.
Yeah, and I appreciate that. One thing I'm learning, as a landlord, is it matters who we bring in. Even after the building's done and we're done and, we're re-renting it, we need to make sure that classification will work for who's ever coming in. That we have the park, because you can't go buy more property to make parking. I mean, that's almost impossible to do.
And I think speaking as a commissioner, I want to be supportive of actual uses in your space.
Yeah.
But there is a process.
Yeah,
If you
okay.
want to.
Thanks.
Okay, thanks. All right, so I'm inclined to follow the staff recommendation in the staff report to table this, to give the applicant an opportunity to work with staff to be able to either see if they can make the table and the site plan work or request the modification. We do still have the Army Corps of Engineer letter issue outstanding that, probably need to get that going or figure out what's the status on that is. And then, of course, the other two items on the,
Just real quick on the wetland delineation.
Yep.
If indeed that delineation remains effective, that's the key component to me. So the letter covered a different piece of property, and we've added to it, and it may be out of the wetlands based on a delineation. we need the date and effective duration of that delineations. My experience is it has expirations.
Okay.
So it may not require if it's still in place, and we'll check with our engineer and those who map it. If it's expired delineation, we're back to the Army Corps.
But it's not us who decides that.
Oh, so I mean, with, in the staff report, number one, the number one directive was to provide the Army Corps of Engineer letter for mitigation of wetland for that given parcel.
We're assuming that it's expired.
Okay, but if he provides that letter and it's not expired, then,
The delineation is different than the letter.
oh,
So
sorry.
like UDOT delineated for the Legacy Parkway, it went down to 23 acres. It's now back up to 56 because the delineation expired.
So for the missing directive on the motion, are we asking for a delineation or are we asking for a letter?
Well, if the letter comes, that handles it. If he doesn't want to provide a letter, we want to know the date of the delineation and has it expired.
Okay.
Can I ask a question?
You bet.
Lisa, I just have a question about if we were to vote in favor of a denial, what would happen next? Is there a tolling period for reapplication?
I think our ordinances only have a tolling period for rezones,
Okay.
so there's not a tolling period for site plan.
So the outcome for a denial would be pretty similar to tabling?
Well, they would have to reapply and pay the fee again.
Oh, okay, never mind then. Thank you.
I think that's, if we can avoid that, let's,
Understand.
yeah. Okay, so, sorry, Corey, I'm gonna go back to your thing again. So we're asking for a letter from the Army Corps of Engineers.
Clearing the property from the wetlands or delineation that still has an effective date. Because what he's saying is all my building is outside the line.
Yeah.
I just want a delineation that's still in effect that says, yes, you're outside the line. If that delineation is expired, then the wetlands can move.
Or a valid delineation?
Yeah.
The property we bought is outside the line.
Okay, well, so a delineation would be able to demonstrate that?
Yeah.
Okay. Well, then I will make a motion to table the final site plan for the pasture phase 3 at 1230 North, 1300 West with directives 1 through 3 in the staff report and an additional number 4 to provide a letter from the Army Corps of Engineers clearing the property of the wetlands or a valid delineation of the wetlands. Okay,
A second.
thank you. Okay, any further discussion on the motion to table?
I'll discuss it.
ahead.
I was inclined to deny. I think the fact that applicant would have to reapply plus pay a new fee is probably draconian. However, deeply concerned that we specifically spelled out requirements that were not met because the applicant felt, I don't need to. I disagree with that.
Any other discussion?
Can I give a comment on that? Just
No.
No.
So let's go, we'll start, if nobody else has any other discussions or anything on that, we'll start at your end this time. Aye.
Aye.
Aye? Aye. Aye. All right, thank you. So this, go ahead and work with the staff on that one, and we will get, hopefully we'll see you again in the future, so. Let's move on to the next item on our agenda, which is it's also an administrative decision. We're on a roll with our administrative decisions tonight. This is for a final site plan for the ACC Auto Truck World. We'll turn the time over to Corey.
Thank you, Chair Daley, members of the commission. Just up front, just to let you know where we're at in working with the applicant heavily with the site plan. They did submit a conditional use permit. In looking at the conditional use permit, I was trying to figure out what we were amending and so forth, and staff missed the deadline for a public hearing under the conditional use permit. So they did submit it. It didn't address everything that would be expected under a conditional use permit, not trying to be mean to them. So a little bit of mistake on our part is we didn't notice the hearing in time, because it's got to be far in advance of the notice just for the meeting. the final site plan, so we missed it. And that's all I can say is we missed it. So,
So along those lines then, Corey, this is a two-parter then. We got the final site plan and the conditional
Yeah.
use permit. If we were to approve the final site plan, does that help the applicant get underway with what they'd like to do and we can
well, I
notice?
think this is the call you have to make. I mean, typically, we don't like to pre-approve conditional use permits because we don't know what's going on with the property.
Yep.
Obviously, having a site plan, like a component, you could look at a number of issues that you're trying to mitigate that may affect the site plan. And if you have approved site plan and then you come back with further mitigation, does it affect the site plan negatively in the sense of they have to completely change it or substantially change it? Or are we just simply adding conditions that mitigate the use? So here's the approach that staff took. Conditional uses are for the use. Yes, they can involve site plan issues of buffering and so forth that would come into play in order to mitigate that use. We missed it, so we are just egg on our face for that. We missed for the public hearing. So we approached it, and this was my approach, which is me trying to accommodate heirs. So you have to decide whether it's worthy to accommodate those heirs. But I am suggesting a condition that the conditional use come back within a certain period of time to secure it, because we're not just dealing with buffering, we're dealing with modifications to the original terms of the conditional use that are not affected all by the site plan. An example would be, is the original condition had a certain set of hours of operation. In looking at the website and the research, it changed the weekdays. Not much, but it changed. And so I don't have an answer from the applicant. Do they want to stick with the original hours of operation? Do they want to modify it? I've assumed that they'll want to modify it at some point. It has primary, and this is where the past comes to haunt. No good deed goes unpunished. I don't know what the good deed was. But it says under the conditional use, primarily new car sales. Okay. Well, lucky for us, new car sales and used car sales are both conditional uses under our standards. I have no explanation what it meant by primarily new car sales. I'm assuming it was a new car dealership. They probably take in some trades, sell some used cars. For whatever reason, the past said primarily new cars. Well, we're pre-owned trucks. So
Yeah.
we got to fix. It doesn't say you can't sell cars in this zone, but they're two different uses for whatever that past is. And they're both conditional uses, so we got to amend that part. We got to check the hours of operations, and then if there's any potential impacts on the site. Now, my view of the site plan is it's already requiring buffering relative to the residential area. It's already under the site plan doing the detention. We're not making necessarily those findings for the conditional use, but I was less worried about the site plan component of that conditional use review, because I actually wrote the entire conditional use permit review. And my focus realized that hours of operation, primarily new car sales, were things that need to be fixed on the conditional use, which I don't think even the applicant was aware of the original conditional use. So the issue is, I believe we mostly hit the site plan issues. I think in the report, a lot of it should be positive with that. I do bring up some verifications, and they submitted some later photos of the lights. They are the shoebox lights, so they meet our code. But I've just noticed in time, sometimes it's bright over there, and I think I recall that they had the big Land Rover box, and they had those big portable lights shining on the big box. Maybe that's my recollection, that the lighting was not controlled, but they do show pictures of the box lights. So some of those technical issues I brought up just to make sure. So I think they're mostly there for the site plan, and in order to allow them to go start pulling the improvement permits so that they could start grading, bond for the drainage, start grading, get going. If they come back with a conditional use permit to amend, probably the more problematic is hours of operation and type of use. That's how I approached it, to try to salvage it, since you only meet once per month, and the deadline for November has passed. So what I did is pre-set the item for your November agenda.
I wondered why the date was like 11 times. Like, what?
So, yeah, so Corey, that, back to my question then, is if we were to proceed with the site plan, that would give the applicant an opportunity to do the poll permits and stuff like that. And we can revisit the conditional use.
Yeah, what the issue really will look like to me mostly is that if they need the pre-owned cars and the hours of operation change, that's where they really have the need to amend the sales. The sales are already going on, it's just for primarily new cars.
So technically, they're outside of the
Yeah, so
existing
to
conditional.
fail to
use
do it in 45 days, you're just back to the original conditional use permit, have enjoyment.
Okay. But then, in my mind, and I'm not gonna again speak for the whole commission, but the site plan here is not affected by the two real changes that we're talking about for the conditional use permit, which is hours of operation and adding used cars to it.
Yeah, I would just give you a little cautionary tale that if there is some mitigation of noise, odor, dust, that can also be included in a conditional use permit review. But I think the site plan is providing those elements already. Sales are going on, this is just a short phase expansion. That phase expansion is going to put in the buffer with the detention and the screen wall and the landscaping.
Yeah.
I'm not sure we ripe for finding additional, all the repair, all the office uses are far to the north away from the residential. They're already conducting sales there. We don't have some problems there.
Okay.
So I'm playing a little bit of risk factor.
Right. Sorry, Corey, I kind of hijacked your presentation. Anything else you'd like
Nope,
to?
I think the staff report speaks with just confessing the egg on my face.
Okay. All right. Anybody else have any questions for staff?
I'll lead out. Corey, question, why the 6 o'clock cutoff on Saturday? Just curious. Like, because if it's a conditional use, we should permit it, but we should tailor it. But what's the rationale for why cutting it off early on Saturday?
I'm with you. You can see that I'm just still holding over the original going,
Sure.
well, if they're okay with this hours, why would I want to expand them? But if they want to expand them, I agree with you. Why the cutoff at 6 if it could go to 7 or 8?
The way I kind of view it is that it's a permitted use, we just only get to tailor it for specific reasons. And if there's no specific reason that we can adduce, I don't see why we would cut it off at 6 arbitrarily on Saturday without a.
And I think that's why it's important to come back with that conditional use, for them to check the hours of operation. If they're willing to live with that, that's great. If they want to expand it, they should be provided the opportunity to expand it and justify why it's okay to expand it.
Yeah, so maybe to that point, maybe let's talk about the site plan for right now. And do we need to table the conditional use permit or?
I didn't even notice it.
It's not noticed.
Nope, it's not even noticed.
Okay,
There we go.
I was going to say, you can't even.
so there's nothing, yeah, okay. So let's
Do
just
you
talk
guys
about,
want you to add, are you going to add a condition to the site plan approval that
I
the,
did, 45 days to amend the conditional use permit. If not, we enforce under the existing permit.
Under
That's
first or second
under-
proposal? There's two
two
proposal
proposals.
recommendations.
No, that's the CUP
Oh,
is the first one.
Sorry, there we go.
The second one is for the final site plan.
There we go, sorry.
Oh, I didn't cut out the pace for the CUP.
That's where I was.
Sorry, I cut out the analysis of the report, because I had a whole CUP analysis, I didn't cut out the most, double egg on my face.
You cut out your 45 days?
No, I cut out
Oh,
I didn't cut out the two actions,
you're right, you didn't cut out the CUP.
but you don't
actually.
see the CUP, I just said CUP component, but there's a whole analysis that was written. I'm sorry, that happened on Friday.
Don't worry, man.
Okay, so, but back to Spencer's question, I don't see a 45-day requirement in that final site plan approval.
Look at, I'm gonna go back to mine, because we gotta
We're on
go back
page
up.
6 of.
Don't ask me again.
So just look at proposed action for final site plan. Oh, which report's there?
I think you uploaded a different,
That's what I'm,
think we have that one.
I don't think,
I've got a whole different report, and I downloaded it from the Novus.
I got it from Novus
I got
today,
noticed
Yeah.
today.
I'm looking at it.
and I'm not seeing it here.
the one on the screen is the one that's attached to Novus.
All right.
Yeah, that's the one I've got in my hand, and I don't, there's no 45-day deal on that one.
Wow, I don't know, because I downloaded this from
See
the
what
Novus.
happened.
How's that happen? What were you guys doing on Friday?
I don't know, because I've downloaded it from there to my laptop.
Did you call it something different?
Okay,
Yeah,
Could you hand
file
that
name.
fourth page to one of the commissioners? So we can see the conditions?
That is hilarious.
Maybe you could just read,
thank you. This is great. This is our best
Wow.
meeting ever.
you could read those
Who
conditions.
knows what I was
We'll
doing?
compare them to what's, because there are some.
Okay, so these are the, yeah, it is condition number 5. So the first the first 4 conditions are all the same.
Okay.
Number 5 reads, "The applicant shall obtain an amended CUP approval within 45 days of the final site plan approval, which shall, at a minimum, address the following." Number 1, or I, alteration of the land use to the sale of pre-owned vehicles. 2, or II, the desired business hours of operation. And 3, the mitigation of potential impacts to the adjacent residential area located to the southeast. For example, use buffering, lighting, screening, etc. So, and then the reasons for action are the same. Not the same.
I don't know what I was.
Number B.
Number B.
Letter B reads, "The Planning Commission finds that conditions may be imposed with a final site plan approval as necessary to achieve compliance with applicable code requirements." Yeah, we've just added with a final site plan approval, haven't we? Okay. All right,
Well, I have no explanation.
it's okay, Corey. We've all been
I'm
there.
just operating in my own world.
Okay. Does anybody else from the, any other commissioners have questions for staff about the final site plan approval? No? Okay. We will invite the applicant to come and speak to this and discuss any of the items we've talked about, the final site plan approval, and introduce yourself, please. Thanks.
Jim Flynn, Hanson and Associates, 538 North Main in Brigham City. I appreciate you. I've never seen that kind of candor in a meeting before. That is remarkable to be able to make things happen. And anyway, we're just happy to be here and basically to answer any questions you might have on the site plan. Sounds like the conditional use permit will be in, and we'll address those items and whatever you have.
Does anybody have any questions for the applicant about the site plan approval? No. Seems pretty straightforward. Yeah.
I'm just grateful the applicant, you got the right report, right?
Yeah.
I got your back.
All right. Thank you.
Thank you.
Okay. Any further comments or discussions? No? All right, well, I'll make a motion. Let's see, I'll make a motion, I hereby make a motion for the planning commission to approve the final site plan for the final expansion phase for ACC Truck World located at 155 South Frontage Road, subject to the conditions 1 through 5. So 1 through 4 that was in the staff report that everybody got, the 5th one that was in the staff report the applicant got that I read earlier, and suggested reasons for action A, B, and C, with B as I read it earlier, so.
Second.
Thank you. Okay, any further comments or discussion about the site plan? No? We'll start on this end.
Aye. Aye.
Aye?
Aye.
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 All right, the motion passes. Thank you very much. That motion passes, so we'll see you back again in a
2 weeks.
Get you there.
few weeks to talk about the conditional use permit. Thank you. Do you need this back? Or do you need
Probably
this?
keep it.
I found the copy in the file.
Oh, okay,
So
good. All
you
right.
can have it if you want it.
Do you want to keep that copy?
You probably got it emailed to you, didn't you? I got emailed that. Good, okay. Thank you.
Thank you.
All right, let's move along then to our next item on our agenda. We've got the Community Development Director's report and City Council report. Corey?
Great.
Corey, this past summer, staff in a township in Pennsylvania just totally forgot to notice, and I had to wait almost 2 months to get back on their agenda. So,
I haven't missed very often, but I won't say that it doesn't happen, but I sure try to
Nobody's perfect.
That's okay.
make it happen.
You make this short and go home and go to bed, that's all right.
We'll forgive you.
We need you for the next meeting. We've got scheduled items. They're always tentative. I'm not sure Canyon Point will be ready. Pastures was discussion tonight, so I listed it on there. The FOCA residence, that's a single-family home east of the Porter Walton Townhomes on Porter Lane. And I pre-noticed the ACC Truck World CUP, so
remind us, where's Canyon Point at?
that is right behind, so if you look at Granite Square on 400 North,
Yeah, okay.
Northeast of
Yep, I
the
was going to
infield
that
development
meeting.
just east of it. So there, City Council, interesting. The City Council wanted to question a few things, three specific matters on the ADU ordinance. They adopted it, but they wanted to come back with some discussion. And out of all of that hour-and-a-half discussion on the original adoption, they only chose one item, to change the 6-month residency requirement for internal ADUs to go to 183 days to match the property tax residency requirement to get a reduction for a primary home. So we'll come back to you with an amendment on the ADUs after that long discussion. That it made it easy. That's the only thing they wanted changed. And then I put your full goals, and I'm so sad Becky missed.
Yeah.
Been a while since we've given the full list of goals that were chosen. But I threw that on there because doing the year-end report on the modern income housing, that'll go to the city council because they're required to do that each year. And just thought, you ought to see where you're at with your goals. Parking study, I talked with them. They should have a recommendation by the end of this month. And obviously the subdivision food truck ordinance. Lisa and I someday will finish our drafts.
Food truck ordinance is in its final draft.
Yay.
I would say,
Hey.
we're getting there.
You had a goal of single-family unplatted lots to kind of move that either to a one-step or a staff administrative approval. This is where it's already a lot of record, and instead of running it through the multiple steps, either a one-step or either a zoning administrator permitted use approval. We haven't decided. That was on your goal list. And then there's still budgets in the plan for that general plan economic update study to the city. So we anticipate post-election, after the first of the year,
Remind me, are you guys gonna do that, or are you gonna
we're gonna
put out an
probably,
RFP?
we're gonna RFP it out because we want an economic component as part of it too. So we'll have a listed element of strategic things that we want to look for, because it's not a holistic, brand-new general plan per se, but we have outdated elements, general elements, like our housing, transportation. Our neighborhood plans have had those Band-Aid improvements and likely not to change a whole lot. But that bulk original one, it's got some outdated stuff in it. And we want to do a better job comparing the Wasatch Front Regional Council, what they're planning on the transportation, what's the city supporting, put that all into the plan and coordinate it with our housing. And then the city council or the RDA wants to look at adding some money to that study to have somewhat, the best way to describe it is a 15,000-foot level economic market study. Where is Centerville in the market, and what does it mean as a part of that? So job creation, preservation of, city revenues, kind of looking at it. And if we're gonna have a job center out west, what's our potential market to cater to, and what kind of changes we'd likely have to make. So that'll begin sometime the first quarter of next year.
Okay. Thanks, Corey. All right, final thing on our agenda, we'll go through this kind of quickly. We'll talk about our minutes. Minutes from our Wednesday, October 13th meeting. Does anybody have any changes on page 1? Page 2?
I got a change.
Okay.
Line 46 should probably, I believe, the language that we were to use, based off Lisa's recommendation, would be a long-term stormwater facilities management maintenance agreement. Is that right?
Yes, good catch.
Got it right the second time, 2 weeks later.
That's great.
Will you say that one more time?
Oh, come on.
I'm sorry, but
Long-term stormwater facilities management plan.
Maintenance
plan.
Almost.
Almost, jeez.
Okay.
So close.
just for our recorder.
Thank you.
I do have one other thing on line 22 of page 2. Chair Daley expressed the opinion that the final site plan application was not watertight. I'd like to change the period to a comma and add, but that he could be convinced to vote for approval. I think that was important because I did say that and I ended up voting for it, so. Anyway. Okay, anything else on page 2? What's that? Okay. Page 3, page 4, page 5. All right, I'll entertain a motion.
Motion to approve.
Thank you.
Second.
We have a motion and a second. We'll do this one together. All those in favor say aye.
Aye.
Any opposed? The motion passes. I move we adjourn.
Second.
All those in favor? Aye. Any opposed? Thank you. We are adjourned.